At least we can go home with that. Okay, so it's a little afternoon on March 3rd in Senate Economic Development. Thank you, committee, for coming back. We're still going to try to get out the Afghan asylee resolution and parole system, asylum, and this S49 genetic information privacy bill. I think we can just have a little bit of discussion on the Afghan resolution. There's David. We're just going to go over the Afghan resolution and vote on it, hopefully. It has, I think, 27 signatories in the Senate. And we heard from two people, one working with families to try and reunite and get people to safety, as well as someone who is speaking with the firsthand experience of others in this community. Anything else that we want to discuss?
Sure. Thank you for the opportunity, Madam Chair. I've just been aware of the Afghan situation by being from Brattleboro and then working in Winooski, and those folks from those two locations contacted a couple of us about 6 weeks ago, I think, and wanted to come up and speak with us, and we talked to them at in the cafeteria, and several other legislators stopped by to see what was going on. I believe Nathan, the attorney, is donating much of his time, bless you, to this. It's a, you know, when you hear the individual stories, it was traumatic enough to come here by yourself. They couldn't take their families. The Taliban said that they would not, there would be a kinder, gentler Taliban, and obviously that hasn't happened. So they're targeting folks who help the Americans. So it's a really tragic situation. The commitment that the U.S. government made to process these applications quickly was seen by others in that field as possibly an unreachable thing to do administratively. So people are not surprised that that's happening. I still think it's valuable for the state of Vermont to take this action and show our support. And I have spoken with the folks of our federal delegation about this, and they're supportive of this action. And once it's all finished, we'll publicize it more. No one said no to signing on the resolution, and it's bipartisan. I suspect if I had spent more time, I would have been able to get all 30 of us. But I wanted to get it done. So I really appreciate the support, and we need to help these folks. So I'll move approval if I did do that. All right.
Okay, it's been moved. Do we need a second? Second. Okay. Senator Clarkson, I'm not sure if you can hear us. We're about to vote with discussion of any kind. And I think you alluded to this, Senator Harrison, but it is, if we can vote it out today, we can let people know over the break that it'll be up on the floor at a time when they can, watch at home or just pay attention and feel seen.
So that's a good idea.
I'm going to text Senator Clarkson. Does anyone else want to discuss anything? Oh, okay. Well, we can hold it open for her while we have the other discussion as well. So you can call the roll, Madam Clerk.
Okay, Senator Brock.
Yes.
Senator Clarkson
So you can
is
just
not
do the
here.
blank right now.
Senator Cummings.
Yes.
I'm voting yes. Senator Rom Hinsdale.
Yes.
Thank you.
So we'll just leave it open. I think
I just hear her beeping in.
someone else might have brought. Okay. Attorney General. Okay, out of nowhere. Okay. Yes. Hello, Madam Attorney General. Thank you for joining us.
Hi, Madam Chair. Thanks for having me.
Yes, so as you hopefully have become aware, and we really appreciate you coming on short notice, S49 does not seem to have a lot of objection. It's been hanging out on our calendar for a little while since we had a bill introduction. It relates very narrowly to genetic information, privacy, and we'll, wait for House Commerce to do its work on the larger set of data privacy issues going on. And as hopefully you also are aware, there have just been two changes requested to S49 that make sure there is we define express consent around sharing genetic information, and then focusing on that latter section on a private right of action, and instead using language that's in existing statute, as I understand it, looking at our ledger council.
I'm sorry. Yeah.
I don't know. I think we heard that the second proposed amendment, that the Attorney General and State's Attorney shall have sole and full authority to investigate potential violations, is existing somewhere else, maybe in chapter 63. Okay.
It is. Yep. That's right. It says that already. It says Attorney General and State's Attorney.
Okay. Okay. So that's helpful. Senator Clarkson was the one who wanted to make sure that you were heard. So Madam Attorney General, you're welcome to say anything you'd like about the bill, and then we'll are you ready to?
Yeah.
Okay. Okay, yeah. So please proceed.
Okay, I have to admit, I only read the bill a few moments ago, so I have not done a very thorough analysis, but I just wanted to flag a couple of things. The first is there is a bill that, as you referred to, being looked at right now by the House Commerce Committee that involves biometric information more generally, DNA being a subset of biometric information. It would be impacted by whatever bill comes out of the House, because David drafted both of those bills. I'm sure the definitions are in harmony, but I would just flag that those are going to be kind of ships passing in the night. And then because you flagged as the main issues that you're focused on for this afternoon, the private right of action. I don't want to take up a lot of your time, but so let me just summarize. I have been working on data privacy issues for the past 5 years for the Attorney General's office, starting when I was Chief of Staff. I have participated in and led a number of forums and conversations about data privacy generally and biometric information privacy specifically these past 3 years. The Attorney General's office had proposed a Biometric Information Privacy Act going back to 2020, and have every year since then proposed something similar that would reflect what we call a BIPA. So that's where my background comes from when I say the following. I believe that a private right of action is very, very important for a number of reasons. There is a state that currently has a private right of action. That state is Illinois. It is the first state to have a Biometric Information Privacy Act. And we currently have a private right of action in our Consumer Protection Act. It's not something that we're not accustomed to here in Vermont. I think it's really important to allow the average person to have that right. I think that that's sort of a Vermont philosophy, to empower the average person to have that right. We also know that if, to the extent that there are bad actors and there are businesses or others who are violating the law, the Attorney General's office is only so big and can only bring so much, so many actions with its current staff. And allowing for a private right of action means that it's not just the Attorney General's office or the state's attorney who can bring an action. A private right of action is also possible. So those are just two examples why I think it's a good reason. Language could be refined, and I get that. I have heard complaints, for example, about the Illinois private right of action, and I'm not saying that there aren't opportunities to make it better or stronger, but I would absolutely include a private right of action. I have seen consumer advocates. I know that you haven't had a lot of testimony from consumer advocates, but all the consumer advocates who have testified in the process that I have participated in have testified in favor of a private right of action, and I would join them in thinking that it's a good idea.
And so our understanding from folks who are here from the genetic information industry leaders, Ancestry.com, representing 23andMe, et cetera, are bringing us language that pretty closely mirrors what exists in other states. And it seems to be specifically narrowed to, you know, the actual industry bringing forward what they hope will protect people's genetic information as it relates to this kind of narrow subset of work that they do, where people pay to have their genetic information studied and, you know, reflected back to them, and express consent is then required for any other disclosure that could ever occur around that information. I don't want to speak for them in case, you know, they wanted to respond to that, but I think the point of this bill was to keep it separate from the rest of the larger bill that, you know, is probably going to have a lot of details and be quite a behemoth. And this is brought to us by Senator Lyons to just help us make sure we're meeting the industry standard for this particular type of transaction that we really need to.
I haven't had a lot of time to look at the bill or compare it to the proposed, you know, H121. So I can't really speak to how they interface or why they should be separate, because because it's like you say, it's a broad bill. So there's a lot of different industries that would be subjected to the law. So I'm sorry to say that I can't really speak to that because I just haven't had a chance to really look at it. Sorry.
Okay, well, House Commerce is anticipating us sending this bill over while they continue their larger work. So if you don't have any major objections, I feel like you could continue to have that conversation with House Commerce and see if ultimately they want to fold it into, you know, their larger bill. But, you know, I'm just sort of offering that as an option unless you feel like there's a huge objection that you want to raise.
No, that's fine. Other than the private right of action, that's the real obvious one. Yeah.
Senator Carson.
No, I was just going to say perhaps David, I doubt, I mean, he's just had a short time with this. I mean, I think that's the concern. I mean, thank you very much, Charity, for taking the time last minute to come and join us. I appreciate. You know, I'm not sure if we're getting a bill on data privacy from the House, is there a reason that we need to do this separately or just wait and fold this into what they're doing? If we know we're getting it. I guess
we don't know we're getting it. The last meeting I had
question.
with House Commerce, we don't know we're getting that bill this year. This would put us in line with a lot of states that are trying to protect people's genetic information on this particular these websites. And if you don't mind, I'll let Richie from Ancestry.com help answer that.
Yeah, so a couple of things. We reviewed H121. We don't believe that definition actually captures genetic information. DNA is not specifically included, and biometric information and genetic information are very different types of data, right? Biometric information is a physical measurement of the size and shape of something on your body. Retina, fingerprint, facial geometry. It can be collected incidentally to your use of another service, and often without the consumer's knowledge. And it kind of goes back to the side conversation we had during the break before we started, where the direct-to-consumer genetic testing services have a different model on data, right? You either pay for the test or you pay a subscription. We provide something in return, and we don't use your information to monetize it for advertising purposes or creating targeted profiles. So it's one of the reasons we've argued to keep us separate from biometric information, because how that data is acquired and the privacy considerations around that data are very different. And the Attorney General referenced Illinois. Illinois has separate biometric info privacy acts and genetic info privacy acts. There are only 3 states in the country that have a biometric info privacy act standalone, and that's going to be Texas, Washington State, and Illinois. None of them include DNA in their definitions.
Okay.
So we strongly advocate to keep those separate because the privacy considerations, again, are different. And the business model for the companies who are collecting genetic information is also very different. So the idea that consumers don't have some kind of redress if we misuse their data is also not true, because this bill will require us to put things into our terms of service and our privacy statements. Those are contractual agreements with the consumer. If we violate the statute, absolutely, we're looking to the Attorney General to enforce kind of the back end provisions and how we process data, investigate privacy violations, et cetera. But if that happens, the consumer has an avenue to enforce because we have violated the contract that we have with them to use our service.
That's really helpful.
And I'm also, I can't see the AG, so it's kind of weird
Yeah,
talking to her with my
her
back.
hand just went up, so.
Yeah, and I'm happy to meet with the Attorney General office to talk further about what we've done and how the other states' laws are structured as well.
Mhm.
I just
Attorney
want
General.
to point, sorry, I just want to point out that an avenue of recourse through breach of contract is different from an avenue of recourse through something similar to the Consumer Protection Act. So it's not that, I understand a breach of contract claim might exist, but just wanted to flag there's a whole body of law about the Consumer Protection Act. So those are just two different kind of areas. I still think a private right of action makes sense and would advocate to include that.
So when you spoke about all the states that have a separate statute around genetic information, they don't include a private right of action there because it's a different type of transaction.
Correct. So California, Arizona, California, Kentucky, Maryland, Utah, Wyoming are using this language and have no private right of action in them. Wyoming has a very narrow PRA after a right to cure. And they did that because they have no enforcement agency within their AG's office. But they absolutely were sensitive to the fact that people, would not necessarily understand if there was something that ran afoul with how their data was used as to who might be responsible. So they would have to reach out to the companies and do fact finding before they go to the courts. Illinois' Genetic Information Privacy Act was passed in 2008. That was before any DTC service was even available to consumers.
Okay.
It's very narrowly limited to the transfer of data. It does not include all of the other provisions in the bill. And we were very clear in how we set statutory fines in this bill. These are not minor fines. They might look small on the one-to-one, $2,500 per violation. But if we were in violation of the statute in California and every person had a $2,500 claim, that fine would exceed the valuation of our company. So we put existential fines into the statute to make it very clear the companies take it seriously, and we are not going to get into a situation where we are running afoul of an AG's office or another enforcement agency.
Senator Brock.
This is for the Attorney General. Attorney, what's our experience been on private rights of action? I know we've got one in the Key Town law that we passed a few years ago. Do we have any other experience in as to how they're being used here?
We don't necessarily, because it's a private right of action, we're probably not involved. So I can't, this is more anecdotal than any information that I really have, but I don't see private rights of action as being really common under consumer law. So I guess that's all I can really say about that.
The uncertainty makes me uncomfortable.
The private right of action?
Yeah, private right of action. As
Why,
opposed
Randy?
to something that is an enforcement issue by an agency such as the Attorney General's office for consumer protection purposes.
Well, it would be both. We would have our own enforcement authority, but a person could, just like they can now under the Consumer Protection Act, a person can bring an action.
But you're not thinking, though, as we do in the statute we have, the whistleblower statute, of having an individual be able to sue and depending, have the state become involved in that suit later on. The state decides it has an interest in it and takes it over, which is possible under the statute we have for Key Town.
I don't think they would take it over. I don't think that's how it would work in practice. I think it would
That's
be
how it works at the federal level, and it may, I believe that's how it reads in our statute.
No, it's not that they, I think they would have
In
a
other words,
similar.
the state can take the place of the private individual in suing for because of the harm that the individual did, and the state could in turn become the prosecutor of that suit.
They could, or the person would just have the right to bring a suit on by themselves.
So I'd like to get our ledge counsel in the witness chair, who could
Absolutely.
probably illuminate this for us a little bit more, and
It's getting cloudier.
it's getting cloudy.
Yeah.
Is there a snowstorm?
No,
No, I
it's
think
getting
she means-
cloudier.
Oh, I was like, where?
It's a
What's
metaphor.
about to go?
The sun is still out there, we may all get home.
Well, David will clarify.
Yeah, I'll clarify
Yeah,
everything.
sunshine, Jesus.
So, David Hall, legislative counsel for your record, and so a little bit comically, I've spent the last however long, hour, going back through this, you know, comparing it to, I was looking at the California statute.
Thank you, David.
And, you know, so so obviously I haven't had a chance to compare this to all the other states. I know this is based on model language. They're not the same. There's a fair amount more to the California law. Is it more protective? Probably gets you to about the same place as far as what policies and et such are
What rights you have?
requires, you know, and I think that you know, component of this being model is again, kind of gets you to the same place in the end.
Okay.
I can't tell you if there are distinctions that make a substantial difference. I haven't had time to look at or consider that, so I don't know. So I'm not gonna stand here and say this is equally protective to any other state's version, because I don't know that. But it is protective, obviously. I also looked at the two proposals of amendments, and, you know, the first one, I think it's fine.
How was the VPERG request?
Well, all respect to VPERG, I love the way it's written, and, you know,
Yeah.
you know, it has components. For instance, affirmative authorization is a term that's actually defined in the California statute, but not in ours. So
Okay,
does that matter? Is that a substantive difference? Probably not.
maybe as long as we know it has a definition somewhere in this body of work. California.
I suppose there's a principle that, you know, states can, or courts can look at, you know, other jurisdictions for persuasive interpretation purposes, but obviously not controlling. The second piece is just a policy choice for you. I mean, you can't use this language because it doesn't work the way that it's written, just
Okay.
there's small tweaks that need to be changed. For instance, you wouldn't reference the subchapter. Technically, the way this is written, the Attorney General doesn't have the authority to adopt rules based on this law, so that part either needs to go, or you need to give the AG's office authority to adopt rules.
Does that exist elsewhere?
Well, it does, but it's a separate delegation of authority. It's
Okay.
not like some universal handoff that says, AG, you can go enforce any law we pass by adopting rules. That's
Okay.
not how it works. You have to have a specific delegation of authority to do specific things. And
Did
we-
you see California had the ability to draw appeals, or?
I don't recall, honestly.
Okay.
So,
We're seeing a no, like some of the other states don't really have further rule adoption, but that's a policy choice. so if we
Absolutely.
wanna adopt-
so that's one of the distinctions I'm going to draw
Mhm.
with the construct that we have on the books for the Consumer Protection Act. So that's
Okay.
chapter 63.
Okay.
This law right now, as it's being written, is in chapter 62, because that's where we put all our protection of personal information stuff. It
Okay.
doesn't really matter in the end where you put it, as long as you provide for the things you want to provide for. So that includes, you know, who has the authority and duty to investigate violations,
Yeah,
whether or not rules are appropriate and applicable. I don't think you need to say the superior courts have jurisdiction. They already have jurisdiction. You don't need to say that. The big one is the private right of action, obviously. So I just, for the record, for the billionth time in my career, I don't care which direction you go. I have no policy preference whatsoever. But I do want you to fully understand the construct. The way that most consumer protection laws are built is we say, here's the behavior. So there's a very general consumer protection section 2453 that says you can't commit unfair, deceptive acts, practices in trade and commerce. And if you do, here's all the all the stuff that comes with it. So that gives the AG's office and the state's attorneys the right to investigate and enforce and bring all these different kinds of actions, assurances of discontinuance, injunctions, civil penalties, et cetera. And then if you violate those orders that come through that process, you have even more punishment that can wait in the wings. That's all the machinery of the Consumer Protection Act, and it is attached to I believe, every single provision that is specific to Chapter 63. So not only is there that general framework and that blanket sort of big picture statement, no consumer protection violations, there's also very specific, there's 8 or 9 subchapters of specific stuff that are violations of the Consumer Protection provision 2453 per se, and as such bring along the machinery. That also applies to all the different pieces of Chapter 62, which are like document safe destruction, social security number, data brokers, security breach notice act, all of that stuff. If you violate those sections, then by law, by reference, you are violating 2453, which means enforcement through 2454 through 2461 or whatever it is.
Okay.
So 2461B, civil penalties, says that in our state, for a Consumer Protection Act violation, a consumer individually, so it's not the AG or a state's attorney in the name of the people, as it occurs in other instances. It is the individual has this right to bring a civil action to enforce violations of the law through which they've suffered harm if they've purchased goods or services, through some sort of unfair deceptive practice. And, it's pretty aggressive. It offers the opportunity for triple damages and to recover costs and fees. So it is a way, for individuals to have some basis of recovery that's not based in other law, whether it's contract, tort, whatever. So if that's what you want to accomplish with this, that's fine. You can say, there's a couple of ways you can do it. I mean, honestly, the way I would do it is to say, this would be a violation of 2453, except 2461B does not apply. So you are taking out the private right of action, but you still have all the other stuff that's basically proposing here. State's attorney or the AG's office, they're the people who would have the enforcement. They can do the investigations, they can do the AODs, they can examine your books and records, et cetera, all that stuff. So, and that also includes, usually we have a separate statement that says the Attorney General has the same authority to conduct investigations, adopt rules, issue assurances of discontinuance, bring enforcement actions as provided for violations of 2453. So the question is, where do you want to draw those lines? Because obviously that whole framework is not what's being proposed here. But if I'm understanding the conversation correctly, it really is the machinery of the CPA, but not the private right of action. And optically that may be problematic. I get it, but that's not why I'm here. I'm here on the law, not the optics.
And I think the argument being made is that it's a kind of separate transaction that feels somehow markedly different, that you, without full consent and payment, submitting this information.
That's correct. And, when the best practices were put together that the model bill was based on, they looked very closely at what was in statute and HIPAA and the common rule to make sure that the protections were just as strong, if not stronger. And then there were provisions added, recognizing that the consumers might be able to download their data and take it out elsewhere. The data could be used for marketing purposes if there wasn't a prohibition on that, et cetera. So the protections in the bill that you're looking at are stronger than the common rule, stronger than HIPAA. Neither of those statutes have a private right of action.
What's the committee's pleasure? I mean, I think there are a few options. One is to get over the language recognizing that it doesn't have a private right of action because it's a kind of separate transaction, as we just heard. It's sort of you're getting information that you'd like to have, and there's a lot of express consent required after that. we could, you know, wait to get the data privacy bill from the House, which could take a while. They did not think it would potentially be this session or actionable by us this session. We could take, you know, I don't know, there might be other options, but you know, we could keep taking testimony, but I think we've reached the crux of the issue. I don't think there's like more testimony we need. I think the question is, do we want to move this or not, and sort of be in line with other states that regulate this a little bit differently.
Just one question, and that is, do we know if we have any other consumer protection legislation that's going to come to us in the session? I'm wondering, you know, is there a quote omnibus consumer protection bill that this could be part of?
I'm looking to David to see if I'm forgetting anything, but I think
That's what 121 is.
that's the data privacy bill. So so it's data privacy plus other consumer protection issues.
Yes, it's like
Okay.
7 sort of major.
Hence, yeah, I just, you know, the look I got from Representative Marcotte the other day was not one that was like, we're getting this text. Senator Clarkson, did I see your hand before? Otherwise, I'm gonna go to the Attorney General.
I just see that Charity has her hand up. I did have a thought because I think there are other options, but I'm happy to go after Charity.
Okay, Charity.
Thanks. I just wanted to clarify in terms of DNA in this arrangement being different. Keep in mind that the Consumer Protection Act protects acts in commerce, which is many different kinds of acts, a wide variety of acts. You know, when you go to the hospital, when you're buying a blender, I mean, everything we do in commerce is included in the Consumer Protection Act. Like the definition of consumer is very big. So I'm not sure I agree with the statement that this is unique because there's just such a wide variety of examples in the marketplace over which the Consumer Protection Act would have authority or be applicable.
Senator Harrison.
Yeah, with what I know now, and I haven't been involved in this, obviously, you know, but I would not want to ignore the recommendations of the Attorney General. And I just generally believe consumers are typically not protected enough. And so I would want to include, but I've heard you use 2 different terms, I think. There's a civil penalty and then the right of protect. I would want the additional protection for an individual, the way that our other ordinances or statutes are.
When I was saying assurance of discontinuance, is that what you're referring to?
No, I mean, you're doing a lot of initials.
The 2461B right to civil action.
Well, you were saying that Vermont has a statute that provides for protection that individuals can
Yes.
make suits in addition to the Attorney General and the state attorney.
So the Consumer Protection Act writ large is 29 VSA 2453. And then what I was saying was it has just some follow-on sections that comprise the larger enforcement picture. So that includes civil enforcement by the AG's office and the state's attorneys, but it also includes the private right of
Private
action,
rights
which
action,
is the
okay.
2461B component. It has the triple damages, the cost and fees, et cetera.
So my inclination is to continue or to include that.
So just gonna wait till we get the bill from them.
Yeah, if that's a problem now to include that, because I guess I'm presuming that the negative would be liability to the businesses. I can't think of another liability.
Right, they'd have one lawsuit by the state of Vermont as opposed to 15 lawsuits by individual Vermonters. So
Right.
it's just,
But the protections of, at least of these companies, are very strong, and I think it's
Yeah.
wonderful. But there could be other companies who come along in the future that
Who
don't
are not.
have those protections, even though we write it in statute. So I just think I wouldn't want to weaken consumer protection on what I know now.
but right of private action is in the bill as it's before us, right?
No,
Without striking.
It's not.
It's not.
That's
Yeah, it is.
Oh, it is?
Yeah, I
Oh,
thought
I'm
it was
sorry,
in,
yeah.
and would
it
have
is.
wanted to take it out.
Well, that was the proposal was to replace it.
Right.
But page 6
Oh.
says a person who violates a provision of the section commits an unfair, I don't know if that's a typo, commits an unfair and deceptive act in commerce in violation of 2453.
Okay, then I'm sorry, I didn't understand. So I would actually like all of them, would be my preference.
All of.
All three.
Actions.
Yeah, well, the private right of action, the AG, and the Attorney General. But also, I don't feel that I have a lot of experience in this issue, so.
Yeah.
Understood.
So with that said, I think what we'll do is, I think I would tell the chair of House Commerce, because they've been taking a lot more time with this whole issue of private right of action and consumer protection as it relates to information, and just wait for their work to come over. And not try to pass them something separate that might sort of like confuse what they are doing or add on to what they're doing, but just wait to hear their work and where they land.
I'd support that.
Okay.
Okay, just so I understand so 11 and 12, those lines under enforcement,
Mhm.
does that mean
Right.
the individual right of?
Yeah, that is the.
Excuse my
No, it's really
plain
okay.
language.
It's okay. It's good. It's the right question. So this is basically the shorthand construct we use to say, if you violate whatever body of law, in this bill, the context would be this section. So if you violate any part of 2432, then you are committing a per se violation of the Consumer Protection Act, 2453. And when you do that, that is what has all the machinery for enforcement under our current body of law. So in our statutes and the court cases, everything else that's interpreted, the rules that are applicable, 2453 brings along the AG's authority to conduct civil investigations and bring enforcement actions. And it is also part of that machinery includes this private right of action that is available for violations of 2453.
Great.
So by constructing it this way, we are putting it on par with other Consumer Protection Act violations as far as that construct is concerned. And the proposal would be to say, use that same machinery, but, take out 2461B, the private right of action, because there's a policy distinction here that suggests that's not appropriate in this circumstance.
I see. Okay, then I'm
That's the-
against that at the moment.
Mm-hmm.
Thank you.
Okay,
With what I know now.
okay. So, but we're just gonna let it ride.
That's
and
fine,
let
but
House Commerce
thank
do
you,
it.
and I'm sorry to.
Yeah,
But do we
Take
want to
too
wait
much time.
2 years or a year? If the House is not, what I heard is the House is dealing with data,
yeah.
not DNA, not genetic privacy.
This is not included, this
Right,
specific
so
concept is not what's in there.
Right.
Yeah,
So how important do we feel this is? Do we want to send this out, which is now in line with other consumer protections if we don't take out the right of individual action? We could pass it out and it would be enforced because it could get lost
Mhm.
that's got other consumer protections besides data privacy.
Mhm.
Those tend to be very big and complicated bills. This is
Yeah.
pretty simple.
It's pretty simple. What I don't think we have the answer to is why this remains separate in other states and doesn't include the same private right of action from what I understand. So, we could try to answer that question now. Richie, if you feel like there is a specific answer to why this has remained separate, and
Yeah, I think it goes back again to that discussion we had over lunch, where it's a very different model for data collection. It's not data that's being collected as you use another service for another purpose.
Mhm.
It is within the context of a contract with a customer. Like,
Mhm.
I want a subscription or I want my DNA analyzed. I'll give you money for that in exchange for the product, right? And it's also, like I said, been kept in line with HIPAA and the common rule. Ancestry does not have a research program, 23andMe does. So they are doing consented IRB approved research on their side. And I think policymakers, when they looked at this, are like, we're not going to treat one class of data differently than we're treating the same type of data for the same type of research as it is under federal law with HIPAA and the common rule. We would absolutely love to see a federal standard, but I think the question of how we treat non-HIPAA covered health data
Yeah,
is emerging in a very big way post-docs,
yeah.
right? So there's states that are taking up that issue.
Right,
The feds are way behind on that.
yeah. That's a
So
good
we're kind of in this area where
Right,
without guidance from the feds, we basically stepped up as an industry with the product of Future of Privacy Forum and said, let's make sure that for this type of data that is outside of the context of HIPAA, the protections are just as strong, if not stronger. And the bill before you is stronger than the HIPAA privacy rule. There are more protections given to the consumer for the use of this data. So all of that is a long way to say that I think when states are looking at data collection and data privacy, not all data is the same, right? And how that data is collected is not the same. This is absolutely different than biometric information, which can be measured externally without the consent or knowledge of the individual in many cases.
so this is essentially their data that they're accessing through a portal.
Right.
I've done 23andMe, I don't know about others, and I get requests for, if I want to participate in another study and get more information. So you're it's like a medical portal where you're getting your own HIPAA protected information to look at, which doesn't usually fall under the same categories.
Right. So in the 23andMe, they're more focused on health. So you're going to see health risks, health traits, things of that nature.
Right,
Ancestry is very focused on genealogy and family history.
right, yeah,
Right. So you're going to see how much of your ancestry or how much of your gene suggests that you have South American roots versus European roots,
Mhm.
specific countries, specific regions.
yeah.
But you're absolutely right. It's all within the context of the service. It's not being shared outside of the service. And from the very beginning, we've said genetic data cannot be shared without a separate express consent.
Right. And it's a good point that in a post-docs world, it would be nice to sort of protect this like other medical.
Yeah, I think we've got the same frustrations that a lot of policymakers around the country do.
Yeah.
And that technology moves faster than regulation did at the federal level,
Mm-hmm.
right? I think we're going to start seeing more activity in that area. There's absolutely a federal conversation with the American Data Protection and Privacy Act. But this question of non-HIPAA covered health data is getting a lot more focus now. And I think, we're hopeful to see a federal statement so that we don't have to, go state by state and argue what the rules should be.
And a private right of action exposes you to something that you're not exposed to in other states where there hasn't really been an issue raised about.
Yeah,
I don't have a
and-
right to.
We talked about Illinois. Illinois has had their Genetic Info Privacy Act on the books since 2008. It only covers the transfer of data to a third party. So it requires consent for that. In the 15 years since that bill has passed, there has not been one single successful action brought against companies. We have had a handful of meritless claims, which we have had to go through the process and get them either dismissed or in some cases it was, all right, we'll do a nominal settlement to stop this process. And nobody's admitting guilt, but we know if we'd gone through, it would have been dismissed in court and would have just cost us a lot more to do that. So, I firmly believe that the balance for consumers, if you can look at Illinois and say, all right, the private right of action didn't afford them any additional protections, right? There weren't a whole host of consumers showing up and successfully prevailing that their data was used improperly. But we did have these cases that didn't have merit, and that brought the cost up for the companies, and those costs ultimately get passed on to consumers. So I think the most efficient tool that we can use to make sure that the industry is behaving appropriately is the one that we should use. Don't use a hammer when it shows it will work. And I think, with 23andMe and Ancestry both, we've both been to market for well more than a decade. There haven't been big stories of us misusing data. It's just not something we do. If our consumers don't trust us, they're just not going to use us. We are not a necessary part of the delivery of healthcare. It is an optional service to find out more insights about health or genealogy.
Sherry has
Yeah,
it's just, I think your business model is wonderful. I don't see us making legislation for one company. I think
Yeah.
we need to look at worse circumstances and be protective of the consumer, but we'll give Sherry time
yeah,
to talk.
okay. AG Clark.
Sorry, I don't want to speak out of turn or talk too much, but I just disagree with a few of the points made by the gentleman. The first is the language of H121 came through my office as a result of several public forum that we had that included advocates, citizens, stakeholders of all types. It was designed to include DNA in the definition of biometric information. So that's not, I don't agree with the statement that it doesn't. I also would
So
note that,
DNA is included in that
well,
bill?
yeah, if you look at the definition, and David maybe has a different understanding, but my understanding is that it is included. It's meant to be comprehensive. The definition is meant to cover all types of biometric information. There was not intended to be a carve out for any specific kind of biometric information. It was meant to be a broad, comprehensive BIPA. And speaking of BIPA, I think my hunch is the reason why there is a separate bill or separate law in Illinois is because technology changed since then. I'm guessing that could be one of the reasons why there's a separate approach. That was the first BIPA in the country in Illinois in 2008. And there was one more thing. I don't have a pen and paper, so I didn't write down my thought. So I'm sorry, I can't think of the final thing, but just wanted to make those observations. Oh, this is what it was. There have been many settlements as a result of the Illinois BIPA, most famously the Facebook settlement, which was only, I don't know, maybe Senator Clarkson remembers 3 or 4 years ago. It was like almost $1 billion settlement. So I don't think all the claims that are brought under BIPA are frivolous by any stretch. Some of them certainly have merits and have had very public settlements that are large numbers.
So when you say the bill went through your office, did you define biometric data?
It's defined in the bill. Yeah. Do you want me to
Okay.
read it to you? Because I actually called it up to confirm my memory, if it's helpful.
Sure.
Sorry, just before Cherry does that, I sadly have committee at 1 o'clock.
Oh, it's done. Okay.
So
So we're,
I would hope-
I don't know that this is gonna be a priority for the week we return from crossover. So we're just gonna have to wait until we get a bill from the House on this. We have other bills we're gonna have to do. Okay, thank you, David.
Yeah,
Thanks
sure.
so much.
I'm happy to help.
David, where's 208? Is that coming back to me?
I'm sorry.
208, is that coming back to me?
Thank
today?
you,
I
thank you.
haven't
It's been
submitted
so
anything.
hard.
If they get to it today,
Does
yes,
it come to you or to me?
come to me first.
Okay.
Haven't seen it yet.
Okay, that's okay.
So we at least got a
2 days to
resolution
get
done
that.
and, oh, you didn't get Allison's vote?
Oh, darn. Is she still there? Oh, no, because she went to the other committee.
Let me call her. Cause it
Do
was.
you want me to text her?
Well,
We should be down in GovOps. Well,
Not
at least on the line of
virtually.
GovOps.
Yeah, I could run to another screen.
Yeah.
let me get her back on before we leave live.
Okay. Some of
Hi,
this-
can you get back on and vote on the Afghan resolution if you'd like to do that? Okay,
All right.
okay, thanks. Okay,
Thank you.
and you're gonna, I imagine, report.
If you would like me
Thank you so
to.
much.
Information.
Thank
Thank
you.
you.
Really
Thank you.
nice to meet you.
Yeah, absolutely.
So you, are you,
Okay.
is everyone okay with this? Are you willing to report?
Yeah,
The resolution?
yes, you just have to let me know how to do it.
Okay. And how do you vote, Senator Clarkson?
Clarkson, yeah, yes.
Thank you.
Senator.
It's unanimous.
Yeah. Okay, Senator
And
Harris is
we're out.
gonna report it. And you can leave as needed. We can go off live and we can explain to you how to get